Okay, we ready to go? Mr. Higdon, is that you here?
Your Honor, my name is Patrick Chidney. So
I'm sorry, you're the one that's going to argue. Okay.
Yes,
All
Your
right. Are you ready, sir? You're going to reserve 5 minutes?
Yes, I am. I'd like to reserve 5 minutes.
Okay, please proceed.
Good morning. My name is Patrick Chidney. So I represent the appellant. The appellee in this case owns and operates a hospital in Punta Gorda. My client was a project manager for an air conditioning contracting company. The company was hired to repair the HVAC units on the roof of the hospital. And the nuances of this are a little important. The area where this HVAC was being repaired was over the recovery room. Because patients would be going in and out, there were requirements the airflow not be cut off. The bottom line here was my clients had to return either late at night or early in the morning to continue doing work. My client returns around 6 in the morning on Saturday after the Friday where they began. He's walking across the roof to get some cones to mark off an area for a crane and falls through a hole in this dark roof. The characteristics of this hole are extremely important. The best places I've seen to view what it looks like are in the first supplemental record at 1592 and at 1612. It's essentially a large, unbounded, unlit roof of an atrium that hadn't been used in 15 years. It's a rectangle flush up against the second floor of I guess the third floor of the hospital, the second floor roof. And there's another small rectangle within it. Geometry is probably my highest level of math. I think it makes it a hexagon. There's an unprotected edge and no guardrail. There was expert testimony at trial that at night, this thing took on some very important characteristics, that at night, you could not really see the edge as opposed to the roof. And there was low light, but that low light actually caused additional problems. There were raised piping and things in the area that cast shadows, made it very difficult to distinguish the edge of the roof from this hole. My client falls through the roof, and after a 3-day jury trial on negligence, the jury is instructed on negligence and the hospital's duty to warn and maintain. The jury returns a verdict finding the hospital liable 10%, my client 50%, and his employer 40%. The trial judge after trial enters a directed verdict saying that there's no duty owed, at least as to the duty to warn, because my client saw this condition during the day. That's borne out in the record, but the standard for the court today on a directed verdict is there any evidence to support any of the negligence theories presented to the jury? Conversely, there must be no evidence of any of the theories of negligence presented for this directed verdict to stand.
Mr. Chidney, this is how the building's designed, correct? Since 1947.
That's correct.
I mean, you characterize this as a hole, but it's been there since it was opened, got its CO as a hospital. So if you're a roofing contractor with 31 years of experience and represent yourself as the safety person, you've been up there on the roof, you see it. I think you finally did concede that he had seen it. If not, that's a little bit disingenuous. There's no doubt he saw this. My question is why does it become patent in the dark when you know about it in the day, you know where it is, and if you're going up there in the dark, you still know it's there? I know you use the analogy of a pothole that you see during the day, but then you hit it at night. That's still your fault. So the point is, he tells his crew, wear your helmets, wear your lights, take your flashlights. He testifies to that. They did it, they were supposed to. But I, being the supervisor, didn't need it at all. And he goes up there. His crew, he makes his crew go up there, and they've never been up there in the dark. Plus, he testified that this job was never supposed to be done in the dark. But yet, he's going up there to get cones. Why would you go up to the roof and get cones for a crane? But yet he goes. He goes and says that he can see. He can see enough to step over something. And then that, unfortunately, I mean, I'm not belittling your client's injuries whatsoever, but he fell. He fell in a hole that he had seen. We don't like taking away jury verdicts. Trust us. We don't do that. That's exceptional. But tell me, why does this become transformed into a patent defect when you know about it simply because it becomes dark?
Sure, Your Honor, I'll take a couple of those in a couple of pieces. My client's first of all, not a roofing contract. He wasn't hired to maintain this atrium or anything.
Is he a roofer, sir? Let's don't get into this. He's a professional roof person, correct?
He repairs HVAC units for the last 30 years. He's been on roofs.
roofs.
He's familiar with roofs.
He says he's been on hundreds of roofs.
That's correct, but this contract was not to repair this condition, and that's the important thing here, is that this condition took on different characteristics at night, and the standard we're on is directed verdict. This is not manifest weight. If there is any evidence the directed verdict was improper, and this is the evidence that this condition that he saw during the day, he did not see at night, and we know this all the time. If it were true that you owe no duty to warn, we wouldn't have flashing lights on cell towers as long as a pilot flew by it during the day. We have known that navigating intrinsically dangerous conditions that are
Well,
obvious.
hang on, Mr. Chili's. Not everything people do is to protect themselves legally. Sometimes people do things just because it's the decent right thing to do, and they're trying to prevent others from getting harm, irrespective of liability. So a lot of these things occur in that fashion. But doesn't the restatement of torts tell us that there's no duty to warn of a known condition?
Well, the restatement of torts says there's no duty to warn of a condition that is not latent, and that's in the context of duty to warn, not the duty to maintain. But my point here is that.
Well, you've argued that Hauk, who had been there many times, never warned him of this, presumptively because, your client had been on the roof at least 2 times, possibly 3 times during the day and saw it. And I think Hauk's position was, I didn't feel the need to warn him of something I knew he knew,
Well, the point here is not that the roof was dangerous during the day. Everybody admits that. The point is that there is evidence presented that this roof at night is a different animal. And that's the point here, that Hauk actually followed a special, even though he knew this thing was up there, he'd been in there for 15
But
years.
everything's a different animal at night. Even a barricade on the roof would be a different, particularly if you're up there without a flashlight. I mean,
that's
you're
the
going to
point.
bump into all manner of things, pipes, hair handlers, holes. At night, you're not going to see these things. But if you've seen them during the day, they're up there, and the burden's on you to exercise a duty of due care and take precautions to make sure you're not hurt by these things.
Well, no, Your Honor, I would submit that the duty is to take care of dangers that you know to exist. And the point is that there was evidence, there is any evidence, which is the standard, presented to the jury and heard by the jury, that this hole at night, which no one contends anybody saw, is unique at night, that it is different at night. And that's what Mr. Hauk understood. He'd been up there many, many times. When he was up there only at night, he followed a specific electrical conduit because he knew it was dangerous to even get in the area, even though he was very familiar with its location. Even
So if
Mr.
we
Hauk,
follow your logic, his crew should have been warned before he ordered him to go up there, but he didn't. He let his crew go up on a roof in which they'd never been on in the dark. Didn't say a word, didn't utter a warning. They just went up there, somewhere they'd never been.
that's the
But
essence.
didn't he have a duty to warn them?
He did not know of it. He'd never been up there at night.
He
And no one had
sent
told
them up in dark. Isn't it true that he did not have to do this? He could have waited on the crane.
Well, no, Your Honor. The hospital, there was testimony that Mr. McMillan, who was the market director for the facilities, who ran the hospital there in Port Charlotte, they wanted to impress him, so they're trying to get this thing done quickly. But the point is, all of this is an issue of comparative fault. I agree with you. There are things they could have done that could have mitigated the injury.
I'm not so sure, Mr. Chidney. It seems to me that the basis of the directed verdict and the basis of what you're arguing really revolves around legal duty. I mean, that seems to be really what you're arguing, and that certainly seems to be where the trial court landed on this. Suppose for a moment you could wave a wand and describe the legal duty that you would have imposed upon this landowner. What is that duty? To fully illuminate every roof surface at night?
Well, Your Honor, it's sort of two questions. That would be more of a duty to maintain. The duty to warn is simply to say, this thing is much different at night. You won't be able to see this hole at all, which is what.
So just so I'm clear, as a matter of law, if you were writing an opinion, you would hold that a landowner has a duty to an independent contractor's employee to warn them that in the dark things are harder to see.
Well, Your Honor, you're focusing on the fact that, yes, duty is a legal determination. I think everybody agrees with that. But the point here is a directed verdict was granted based on facts that were determined at trial. And I think if you think about it, yes, legal duty is determined by a judge, but there are predicate facts that you have to establish to know the duty.
What you're touching on is way beyond our pay grade to try to figure out, which is the niceties and the distinctions between legal duty and proximate causation, and facts inform both analyses. and foreseeability inform both analyses. And that's something that jurists and scholars have been trying to figure out for decades. And I don't think we're going to do it here in 15 minutes.
I think that's right. But Your Honor, the question is, I don't think there's any case law saying that this was decided on anything other than a fact presented at trial, which was that he had seen it during the day.
But your argument is that there was a duty to warn. Basically, there's a duty to warn that at night it gets dark.
That's not correct, Your Honor. The professional engineer testified that this hole, the way it was lit, and Mr. Houck testified, even with all the lights on, you couldn't really see the whole thing, that the edges of this became particularly dangerous at night. And it was partly because there were raised piping in the area and low light that cast shadows. That created a situation. And again, we're not talking about manifest weight or whether the jury was right. We're talking about a directed verdict where the judge took away the verdict in favor of my client when there was evidence that this hole, whether we all agree with it or not, presented a special latent defect for which, under the law, there is a duty to warn. And that's borne out in the Aaron versus Plot Kamal case that we cite, where someone
didn't the contract itself put the burden on your client to protect this area? I mean, the contract basically stated the contractor would take all reasonable steps to prevent personal injuries.
And
so,
Your Honor,
I mean, not only was there probably not a duty to warn, but contractually the burden was on him.
Your Honor, there was certainly a duty to warn, but I would ask the court to look at what the contract actually says. It's at record 1637, and it requires the contractor to take all reasonable safety precautions. First, I would admit that what's reasonable or what's not was an issue the jury considered, and it's played out in the comparative fault verdict. It shows that the contract was argued to the jury. The defendants argued the contract took this duty away, which is what I'm saying, but I would also direct the court to the Houck versus Monsanto case, which is from the first DCA. That case, the contract with the contractor had almost the same language, was responsible for all aspects of the construction, including safety precautions. The injured employee in that case stepped on a French drain that was right beside where they'd stacked lumber. And this particular drain wasn't filled. He fell through it, was severely burned by steam. The court said that the latent defect, the court focused, which as this court should do today, focused on the latent defect as the characteristics of this French drain. The court said that
Mr. Houck hadn't seen the drain before. Your client had seen this hole, this atrium before. Plus, he's the safety project manager. Plus, your expert, Ms. Campbell, said you should use lights in the dark. No matter what the working conditions are, you must use lights in the dark. Also, his supervisor said he should have used lights. Now, he's got the same knowledge of the roof that the hospital does, and he's contracted for money to work on the HVAC. And I think it's very telling when he testifies that he measured the ductwork to go around something. And then once direct and cross was done, the jury submitted a question and said, you said you measured the ductwork to go around what? What obstacle did you want to go around? And your client testified, I measured the ductwork as an arch and not that close to the edge. I wouldn't want to hang the ductwork over the top of the hole. And you just said you started your argument with the hole. So it's obvious that he's talking about this hole. So he has superior knowledge or equal knowledge that the hospital has. So why does where does the law place the duty on the hospital at that point?
Right, Your Honor, the point is he had equal or equivalent knowledge as to this hole during the day. The focus for the court should be the nature of this condition in the way he encountered it, which is exactly like the Houck case. There were a bunch of French drains on site. People knew those were there. It was not the fact there was a French drain. It was the fact that this one French drain, in this instance, wasn't filled up and no one knew it. And so when he stepped through it, he couldn't respect it. He may have seen this hole at night, but he did not know how it would act at night as the engineer testified. And again, most of the issues you've raised involve comparative fault, and it's clear the jury found my client partly at fault, and we can't dispute that. The question is, could the judge take this away? Could the judge remove the jury's verdict by saying there was no duty at all? And I think the predicate to your position would be that my client had equal knowledge of this latent condition as he found it. The court should focus on what he actually encountered as opposed to its conditions at a different point. And I think the Aaron decision plays that out perfectly, where the court said that someone who knew that there were traffic bumpers in the parking lot, the duty to warn remains even in that instance because it was raining and it was dark. The court said that It's the opposite of an open and obvious danger if it is concealed and shrouded in darkness.
Yeah, but
That's the
that
case
wasn't a
here.
plaintiff who was working on the parking stop.
It's the
Your
same
client
concept.
was working on this roof and was responsible for measuring it, for knowing about it, and keeping his employees safe. He cut the ductwork and ran it right up to the edge of that hole and knew it was there. So he has equal knowledge. Plus, he has more experience as to what he's doing than those hospital janitors or maintenance men. So basically what you're saying is what Judge Lucas says. When it becomes dark, you're just going to have to light up the whole area. Every business owner is just going to have to light up every atrium from now on.
Your Honor, that's a different point, and I know I'm into my reserve time, but the lighting it up is the duty
You
to
are out of
maintain.
time, sir. Thank you for reminding me.
Thank you, Your Honor. The duty to maintain is a little different. As to whether they discharge with the lights is a different situation, and the trial court didn't even address the duty to maintain, which is another issue raised. We're talking about the duty to warn, and all the hospital had to do with the duty to warn is say, you may have seen this during the day, but trust me, Mr. Hout could have said, when I go up there at night, I've been there many, many times. I follow the specific path. I don't trust my knowledge of the fact that this hole's up there because it's hard to see the edge. And there was evidence of that, and that evidence supports the verdict. I'll keep the rest of my time for
Okay.
rebuttal.
You have 4 minutes when you come back.
Thank you, Your Honor.
Okay. Mr. Azarone?
Thank you, Your Honor. May it please the court. The one thing I'll agree with appellant counsel is that this is a case where nuance is important. And I think the first place we need to look is in line with what the court has stated. The contracted issue, which really isn't addressed in either the initial brief or the reply brief, and this is at record 1637, states specifically, contractors shall be responsible for initiating, maintaining, and supervising appropriate safety programs, shall take all reasonable safety precautions to prevent personal injuries and conditions that may be hazardous to the health of persons at or in close proximity to the project, and shall take adequate protective measures to prevent damage to the work and to existing property. The trial court appropriately granted directed verdict despite what the jury had found because, frankly, Mr. Shalatz testified, I saw the hole. He saw the hole, he knew it was there, and the testimony from the appellant's own expert was that he didn't protect it. He did not comply with the contractual duties. And the contractual duties in this case are what make it different from most of the cases that were cited in the answer brief, because many of the cases in the answer brief talk about people who are workers, but the work that's being performed is not pursuant to the contract to maintain safety, to warn of safety. And I think that is the nuance that is missing from the appellant's argument. And it's an important distinction because, again, here, it's not like the cases that are cited where the person goes to do work, sees something wrong, and does the work anyway, and the court finds that there is still a duty to maintain. Here, the case law says where there's a contract and where the work done, where the injury is incidental to that contract, meaning is the injury stemming from what the person who was injured was supposed to do? And I think the trial court appropriately found not only that Mr. Shalatz was under a contractual obligation to find the roof edge, to protect of the roof edge, but also didn't comply with that duty. And your honors have really found the important parts from my argument that the trial court and the jury heard testimony that it was found, it was seen, it wasn't protected, that Mr. Shalatz himself didn't do anything to protect himself. He wasn't reasonable. What appellants want is for the hospital in this case to be the insurer that nothing is ever going to go wrong. Light everything up, make sure it's all there. We need to tell Mr. Shalatz, the contractor, and all the employees of every possible thing that could go wrong on their job site. And that's not what the duty is owed. The duty to warn is to warn of things that you may not find through the exercise of reasonable care. None of the evidence presented in this case goes to comparative fault. It all goes to duty. What was the duty? Because that's what's in the contract. And if you look at one of the cases that I cited in my brief was Roberts versus Dacra, which is a third DCA case, which is very similar to what is occurring in this case. There, a worker was contracted to go and work in a property, and when he got there, he saw that it was dark. So what did he do? Did he use lights to go and light the area where he was going to work? No. He went in, he slipped and fell on construction material in a building where there was construction, and then filed a lawsuit. At trial, he conceded that the lighting or the lack thereof was obvious and that it was his responsibility to provide lights for his work. And he didn't. And the court found that in that case, there was no duty to warn owed. In this case, Your Honors, we have a situation where the evidence presented at trial fully and completely supports the court's decision to grant directed verdict in this case, and we believe that the court should affirm the decision of the trial court. If there are no questions, I will end my argument.
Thank you. Mr. Chilides, you have 4 minutes.
Thank you. I want to go to just a couple of points here. There's some talk about the contracts. I would encourage the court to look at some of the cases that we've cited. We talked about Hauk, but a lot of the cases involve skylights, oddly enough. Unfortunate for the people who are injured, but it's fortunate because we do have sort of a spectrum, and you can see where these cases fall. On the one hand, you have the Fuentes and the Strickland decision, where someone had actual knowledge of the skylights. In fact, someone told him, don't step on the skylight, you'll fall through it. On the other hand, you have Phillips and Pirtle. Phillips, interestingly enough, had a contract to clean and repair the skylights. It was part of the contract. The thing is, the skylights were painted over. The same thing.
The distinction in Phillips is that the skylights were painted the same color as the roof, and they were indistinct. They were not conspicuous. I think your biggest hurdle is this is the design of the building. It's not really a hole. It's a huge, as you said, geometrically, I don't know what it is, but it's enormous, of which he knew about. And he had the same knowledge as the hospital. That's our problem.
Right, Your Honor, but it is conceptually indistinguishable from the painted over skylight because of the testimony that the edge is invisible at night. He encountered it at night, not during the day.
So darkness is equivalent to the paint in the Phillips case.
Yes, it's the same. You cannot distinguish between the edges. It's also the Pirtle case. And in Phillips, there was a contract requiring him to look for these skylights. It's just the fact that when he encountered the condition, it could not be distinguished from the surrounding area. It's conceptually indistinguishable. The point here that I want to bring this back to is we're on directed verdict. Is there any evidence that this condition, that this hole at night is like a painted over skylight? And there is a lot of evidence of that. And for the judge to take this away, there had to be none of this evidence from Tracy Campbell saying that the edge is indistinguishable at night, that it's invisible. Mr. Shalat said that he saw that there was darkness over here. He didn't see the edge. And Mr. Hauk, he said
that the trial court's problem was that given the fact that he had prior knowledge of it, the court found as a matter of law there was no duty to warn, and therefore this should not go to the jury because of the risk of them coming with, doing something wrong with it. I mean, there basically was no, that's the problem. There was no duty to warn, and the hospital basically hadn't done anything wrong, was what the court basically found as a matter of law. Isn't that right? Wasn't that the rationale for not sending it to the jury or taking it away from the jury?
I think that's correct. The fundamental problem is the trial court focused on the fact that he had seen it during the day. And had the trial court said, you knew at night this thing was dangerous, and so you should have done these things, that'd be a whole different story. The problem is there was evidence it was different at night than during the day, and there was no warning about the condition at night. That means that there is a duty. If there's a duty, then the jury can decide comparative fault. And most of the issues that have been raised today involve comparative fault. And that's what the jury decided. We know that from the verdict. The problem is that the trial court said that the difference between day and night is a nuance. The difference between day and night is not a nuance. There's a lot of case law and basic common sense. There's a reason we have lighthouses. There's a reason that I walk into my bed at night when I'm walking around in the dark and I don't hit things all the time during the day. You have to look at the condition in the way he found it. And the judge erred in looking only at the condition he knew to exist. There was evidence, whether we agree with it or not, that the condition was different at night. For that reason, the directed verdict was inappropriate. The court should be considering the condition that he actually encountered. Unless the court has any other questions, we respectfully request that the court reverse the directed verdict and remand to reinstate the jury's verdict.
Thank you both very much. Very well argued and well briefed. We appreciate it.
Happy New Year.
Thank you, Your Honors. Happy New Year.
Our next case is